All right, first on my screen, on behalf of Plaintiff, Kailyn Zirkel, Attorney Jonathan Hexel. Mr. Hexel, good morning.
Good morning, Your Honor.
And Kailyn Zirkel joins us next. Ms. Zirkel, good morning.
Good morning.
And Mr. Kyle Zirkel joins us as well. Good morning.
Good morning, Your Honor.
So I have received a copy of a objection to the friend of the court recommendation. I wish I didn't, but I do. And because it's things start moving at a quicker pace than that. So let me just create a record and then I'll turn to you, Mr. Hexel, and then we'll turn to Mr. Zirkel. So this matter was previously in court on the 19th of May of 2025. Parties actually stipulated to a child support review and an order of reference was entered on May 20th of 2025. On June 30th of 2025, the court received the friend of the court child support recommendation and orders. On July 17th of 2025, plaintiff filed an objection. Therefore, it was a timely objection. So where it goes from here, folks, is it gets exponentially more complicated. And we set the matter up for an evidentiary hearing. Usually on child support, Mr. Hexel, I start with an hour, and then we work our way on from there if it needs to go further. But when you get notice of this evidentiary hearing, it's also going to have some very important filing requirements. Briefs, witness lists, exhibits, exhibit lists, those types of things. And failure to do those things or do them correctly could result in your hearing being postponed or adjourned, or if enough of them happened, even canceled. So pay particular attention to that. If anybody is considering hiring an attorney for this matter, then they ought to do so in the real near future. Also, the date for these must also be cleared through the friend of the court evaluator, whoever did the evaluation, to make sure they are not tied up in another hearing or on vacation or on medical leave, so we don't have to adjourn that matter. So, Mr. Hexel, I have one question and then I'll turn it over to you. Normally, I always inquire in these cases if you think mediation would be an appropriate avenue to try and settle this, or is that just not an appropriate way to do this?
Your Honor, I would actually defer that question to Mr. Zirkel. I'm always open to mediation. I believe it's a great process and a great opportunity for these clients to work this out themselves without litigation. And I think Ms. Zirkel would be willing to do that. So I would defer to Mr. Zirkel.
What do you think, Mr. Zirkel? You think a mediator can help get these issues resolved?
Your Honor, I have been trying to settle on this matter. Mr. Hexel is a fabulous attorney and a great salesman as well. But his general accounting practices are, I'm not really seeing how he's getting these numbers. I wasn't a huge, fan of the FOC result. I thought it was rather high because they did factor a bonus in there. So I just, went with their professional opinion and thought it was going to be okay and I was going to go with it. However, as you see there, the plaintiff wants even more. And then not only even more, but to continue to do this every single year. If you look at our past history, the plaintiff has filed multiple motions every single year. since the judgment of divorce. It's kind of a living hell, looking at my email and just being fearful of another email from Jonathan Hexel. I respect him as an attorney, absolutely. However, they've caused a lot of grief, and I would just really don't want to just bend over to these terms. I think that the FOC statement is, yes, high. I'm willing to go with it, but for them to ask for even more, I got to draw the line somewhere. I do believe that we should, if they do in fact want to fight this, we should take this to court. There are a lot of things that I would like to subpoena. There is a family business that wasn't factored into the FOC judgment. I think that those figures need to be presented. I'd like to see a profit and loss statement of the Groundhog organization where Kailyn works, and it's a family-run business. So I know that there's multiple incentives along with that. I can understand too if, say she was a single mother living on her own, but she is like very well compensated, drives a brand new truck, lives in a, big house with her extended family. I don't see a reason for wanting even more. Even seeing how there was a sign-on bonus and a incentive bonus factored into the calculation. So say next quarter I don't get those bonuses, I'm still paying that $1,080 a month, right? Which is 8 times the typical child support payment for the amount of nights that I'm getting as well.
So we're off to a bad start, you and me. And I'll tell you why. Because I just asked you if you thought mediation would be appropriate. And then you've gone into a 10-minute dialogue and answered and asked and everything but what I asked for. Okay. We're not here to try the case. We're not here to get your thoughts on the case because there's been an objection. It's not that your thoughts aren't important. They're just not important today because what I have to do when there's an objection is I have to set it for an evidentiary hearing. But I try and ask the parties if they believe that a neutral third party couldn't help them with the possibility of getting this matter resolved once and for all. And I was just looking for a yes or looking for a no from you because mediation adds an expense, and I don't want to do that if the parties are not mindful of its ability to resolve the case. So let me try it again. Do you feel mediation would be beneficial? Yes or no?
My apologies, Your Honor. No, I do not.
Okay, then we'll set it for an evidentiary hearing. And you can get with my clerk, Mr. Hexel, probably starting next week. You also get with the friend of the court, whoever did the evaluation, and then we'll get it teed up for about an hour. Mr. Zirkel, I would, based on what I've heard today, I would strongly urge you to retain counsel because some of the things you are asking for, although relevant, may be difficult for someone who is representing themselves to get. So, but the Sixth Amendment lives alive in my courtroom, so you are free to do this on your own. And hopefully things will work out for the best. Otherwise, we'll see everybody in court. Make sure you keep in mind the filing requirements, submission requirements, and we'll get that squared up for you. You're all set with me. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.